So I love the project, but I guess I wonder, just on the merits, whether it's currently taking on the most prominent competing views rather than the strongest competing views. So I do think one strong competing view, which John just alluded to, is sort of what I call the null hypothesis, that there isn't a consistent textual usage of the different phrases. But that maybe they just, can be interpreted based on context. So you can look at the incompatibility clause and conclude based on context that it can't apply to senators or representatives, or also be self-destructing, and so on. That seems to be a lot of people's view, where something like, it's presumptively inclusive, but not always makes sense. I don't know. So you guys have arguments against that, but the current sort of assumption of the piece is that there is a consistent usage, and you're just finding out which one it is. And I don't think you can take that assumption, and you have to establish that rather than assume it. The other strong view, although not held by anybody prominent, is what I think we might want to call the intermediate view, which is that, so if you notice, which I didn't notice until somebody pointed this out, the Constitution never refers to officers under or offices of. Office is always coupled with under, and officer is always coupled with of. So it's possible that under and of are just the prepositions that go with the different nouns, abstract office and specific officer. So one possibility is those two circles are the same, officer of and office under, but the other differences are still there. And that would still get you that the president is not covered by the Foreign Emoluments Clause, but it would suggest that non-apex legislative officials are also not covered by the Foreign Emoluments Clause. I'm not sure if the strongest evidence those two are actually different, and that office under is broader than officer of is. But those seem like at least possible competing interpretations, and even if they're not by people named Amar, they're probably worth talking about.
All right, this was a terrific paper, and I'm uninitiated in this history and literature. So I was convinced until I got to one part of the paper, and so take that for what it's worth, something for more elaboration. You say a public trust for the religious test clause. A public trust under the United States includes the president. But if I understood the discussion correctly on pages 48 and 49, the reason in the antebellum period people didn't think offices under the United States included elected officials is because they were elected by a source paramount to the national government, in the words of Story and his commentaries. But isn't a public trust under the United States, doesn't that suffer from the same problem? In other words, if under the United States means, if an office under the United States can't be an elected official, why can a public trust under the United States be? And certainly, another competing view is public trust or office of trust includes the president. So the president's not usually an officer, but he does hold an office of trust under the United States, so the religious exemption clause might apply, the religious test clause would apply, but so would the impeachment disqualification clause. Anyway, that was a place where you lost me in the paper, and I'd be interested in an explanation of the under the United States difference there.
So I thought this was a very interesting paper. I asked sort of a methodological question. I was perplexed as to why at the beginning of the paper you disclaimed trying to say that this was a public meaning paper. I think perplexed for two reasons. One, it would strike me as sort of help you. I mean, for instance, and I very much agree with John in this sense, I think the beginning of this argument is in a deliberated document, not to say a legal document. If people use terms in different ways, that seems pretty good evidence, really the beginning of the argument, and it gives you a strong presumption against everyone else. That's kind of a kind of public meaning argument. Moreover, in general, in law, we have a normative payoff. So if we put it into our machinery, we think public meaning, we should follow the public meaning, and we, of course, have caveats for that. And once we decide something's the public meaning, other things follow from it. So I was just perplexed as to, it would strike me as a more powerful paper, both methodologically and then ultimately normatively, if you put it into the public meaning box. But maybe I'm confused about something basic.
This is the incompatibility clause, and no surprise here. I just want you to see it uses the office under the United States language. That's all I want you to see there. All right? Josh, could you bring up a British statute? Okay, this is a British statute. This is a precursor of the incompatibility clause. This statute uses office or place of profit under the king. It's more limited. It's limited to places, to offices that are of profit. Under the king means the office times out with the death of the monarch. It's a little more limited than office under the crown, but it also uses pension from the crown, showing you that the crown was usage that was there. And could you go to the next statute? This is the more famous statute, and this is what I think was the precursor of our incompatibility clause. No person holding any new office or place of profit whatsoever under the crown. There's the under the crown language. So there are elements of this paper that are original public meaning papers. My argument, and with Josh, has been that the phrase office under the crown drew from a rich legal and parliamentary tradition. And there are all sorts of cases across the Commonwealth world talking about then and now how the phrase office under the crown is used. I believe that office under the United States happened because when the revolution came, we weren't going to talk about office under the crown anymore. We changed the crown to our executive government, and it became office under the United States. I believe that was the genealogical history of that phrase. That's different, I think, from the appointments clause. Josh, could you bring up the appointments clause?
Yeah.
Here's the appointments clause, and to some extent addressing John's argument. I think the key language is whose appointments are not here and otherwise provided for, and which shall be established by law. I actually agree with much of what John said about the drafting history of this clause. The earlier drafts do not mean what I think the final draft means. I think towards the end of the drafting process, they changed the language that had been an earlier language, and that changed the meaning, and we have to look to the public meaning of what was actually put to the public. I think the weakness with the position John developed, that this language can include elected offices, there are many reasons, but the one reason I want to draw your attention to is this word here, and. To make John's argument work, that and really has to be read as an or. Established by law is pretty well-known terminology in the Constitution. When the Constitution uses the phrase by law, that means by statute. So even if this language, which I don't think it does, could refer to elected office in the abstract, once you couple it with an and, you're stuck with only offices created in the future by statute. So I think that to some extent addresses John's point. As far as, Will, your point, I developed the incompatibility clause example in part to address John's point and your point. But as far as the null hypothesis that all these phrases potentially mean something different, that could be a strategy when we admit that we don't know what it means. But if it's the same language in different clauses, office under the United States, I would think the presumption has to be it means the same thing across clauses. That's not proof. That's more of a presumption. I'm not going to develop a whole argument against the null hypothesis here, but I would simply say that the burden is equally on those people who are making an argument for the null hypothesis, unless they're making a practical argument that we just can't figure it out. I think that's the real defense of the null hypothesis and has been the defense for why we interpret these clauses differently, even when the language is the same. As a matter of fact, there are these memos, that one of which has John McGinnis's name on from the OLC.
We cite you.
Dealing with this language, office under the United States. And the OLC disagrees with itself in various iterations. Sometimes the different OLC officers don't even know they're disagreeing with a prior iteration.
John got it right.
Thank you.
I do not follow Seth and Josh's argument with respect to the addition of this phrase, and which shall be established by law. As I read the actual text of the appointments clause, it is referring at that point to the other officers the president will appoint, and those offices, those appointments have to be established by law. Those offices have to be established by law. I don't follow the argument. I looked at it very closely. I don't think that language, incidentally, is added after the Committee of Style takes its pass. So the Committee of Style does one thing. They add a comma after officers of the United States and before whose appointments are not herein otherwise provided for. The language goes into the Committee of Style without the comma, as it had been the case all summer long where that is not set off by a comma. I don't know whether they think at that point the appositive reading attaches, or they think that after the additional reference to and which shall be established by law was added, that's the point of time in which what had been assumed all summer long converts to a new reading, and the Constitution now reaches out in a different voice to the reader and says, by the way, we are now defining the meaning of officer of the United States, as opposed to referring to two different definite descriptions set off negatively and affirmatively, those appointments which are otherwise herein provided for and those which are not. That's the simpler, more straightforward reading, it seems to me. On the second point, I just want to make a remark with respect to the British antecedents. Seth is absolutely right. These are clear British antecedents. I have no doubt, also with respect to the Foreign Emoluments Clause, that these are the kinds of antecedents that led to the drafting history. But it doesn't settle the matter. We have clauses in the Constitution, like, for example, natural-born citizen, which clearly derive from British antecedents like natural-born subject, but the context and the content change in imperceptible and complex ways when you substitute citizen for subject and when you substitute United States for crown. A lot happens. You don't just get for free the idea that it's all going to work the same way. And you can see this. You can see evidence, for example, that Americans in the early period wrote letters asking for federal appointments, and they would proudly say, I'm a natural-born citizen of the United States, and they were born in like 1740 or something. But they mean something specific by that. They mean we were born on the soil right here. And there was a usage around that term that was different. In the British context, people could become natural-born subjects by statute, like, for example, by serving in His Majesty's Navy as adults. They would then get that designation. It didn't mean use solely birthright citizenship the way it did in the United States. And so it doesn't just follow that you find a locution in a British statute that's very similar, that no doubt did inform the drafting history, that the founders changed with a critical difference. The United States is a legal corporation that sits on top of everything that happens in the United States government. It has powers. That's why the Necessary and Proper Clause is so important. It vests powers it refers to powers vested in the corporation, like the power to own property, to enter into contracts, to sue and be sued. Those do not decompose in the way that Seth and Josh are talking about when they discuss the Necessary and Proper Clause. And the United States is the style of the government. You have to keep focused on that. So just when you have under the United States, it's not the same thing as under the Crown.
Right, well, our next trio is Tom Colby, John Harrison, and Chris Green.
So I think this is a really strong paper. I think it is exhaustively researched. It's incredibly detailed and thoughtful, provocative, characteristic of both of your work in general. The question I want to ask is maybe just a simple one, and that is, I think the paper is suggesting that the presidency is an office, and therefore the president is an officer, but not an officer of the United States. So I just want to ask, what is he an officer of, if not the United States? New York? Canada? Great Britain?
John?
Do you have a position on the historical question, whether Wilson and Morris did all this on purpose? Did they have one of these Venn diagrams or one of those bingo cards in mind so that they really meant to accomplish all this, or do you just not take a position on that?
And Chris?
Okay, 6 very short things. So three things I loved about it that I wish were earlier. So I read this whole thing this morning, okay. When I got to that diagram, I was like, that's nice. I would love for that diagram to have all the different offices and where you put them in the Venn diagram. I think it would be great to have the other 2 views that you're mainly considering. If you've got like cover art for the book, that would be the perfect cover art for the book. 2 other things that when I came to them, I thought, wow, that's a really good argument. I wish that were on page 1. And you both mentioned them here, but members of Congress can be in Congress. The thing that Josh did, and then the 1700 and 1707. I thought, oh, okay, that's the argument. That's the the linguistic background. So I really wanted to know that earlier on. 3 suggestions for things you could do. One is, we corresponded years ago about this. The president is not allowed to have another salary, but representatives and senators have to have a salary. It seems like that alone means that the president can't be in Congress. So, independent of the reading of these clauses, it seems like you can kind of discard one of the really implausible, it seems to me, things about senators being able to be president at the same time. But you can keep all the reading of the stuff you do, but you could say, you mentioned there could be other constitutional arguments against that situation. The simple one, I think, is just the salary argument. when I got to Randolph in the convention, I was like, whoa, what's the deal with him? So yesterday I ran across this piece of evidence from Randolph, and I loved his explanation of the commerce power. So I'm like, a day away from finding this great evidence about Randolph, and then like, you're telling me Randolph was just a goober in the convention. Some sort of explanation of what's going on with Randolph would be good. Finally, so in terms of John's argument, that the necessary and proper clause talks about powers vested by the Constitution in officers. It seems like you could have offices that are created by Congress, but then the powers vested by the Constitution, instance, lower federal courts. So Article 3 says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts. So the Constitution is doing the vesting, but those offices didn't get created until Congress decided to create it. So you have the Madisonian Compromise, and it seems like that's at least one instance of a way to make sense of the necessary and proper clause. There might be some others, but that's the one that I noticed.
Okay, thank you for those three questions. So Tom, first, you asked, what is the president officer of? And Seth began at the beginning of his speech that the word officer has many facets. The word officer depends on the clause in which it's used. Does the president hold an office? Sure he does. It uses the phrase office of the presidency, office of the president. That phrase is used several times in the Constitution. But we don't think the president has an officer of the United States or office under. And there's evidence. Again, if you go to page 36, Attorney General Bates said the president's department of the government. There was an impeachment trial in 1876 where Senator Booth said the president's not an officer of the United States. Again, these are not things that we're making up, but things that have been largely lost to the sands of time. John, your question about the bingo card, right? Was this done on purpose? And I'll hit John McGinnis's question as well. We don't speak in the language of parliamentary drafting conventions. We just don't use that language. For us, this is foreign. But for people who are studied at the Inns of Court, this was a second language to them, right? This was something they knew how to do. And the phrase office under was something that they knew what it meant. It didn't have to be coordinated. Indeed, the only way to explain this slide is with this common knowledge that's simply been lost to the sands of time. We haven't mentioned the Hamilton document. There's a reason why that document is so damn important, right? Had Hamilton listed the president on that document, we'd have nothing. We'd have something, but we wouldn't have a lot, right? But he didn't, right? Hamilton was a very smart, trained lawyer, probably one of the smartest lawyers of his day. And he drafted the document the way he did for a specific reason. Now, why office of versus officer under? We think that the appointments clause does a lot. It specifies a specific type of position that would be separate. And Seth offered an example earlier today that I think is actually pretty good, right? The clerk of the House of Commons received his commission from the king. Even though he was a legislative officer, he received his commission from the crown, right? The clerk of the House today does not receive his commission from the president. He receives no commission at all. We think the of and under, this is some not fully proven, but we think office of and under was meant to account for these legislative branch officials. Today, who cares about the clerk of the House? But there was extensive litigation in England that lasted centuries about what exactly is a clerk of the House. We don't know this today, it just doesn't matter. But it mattered at the time of the framing. I think that's how you explain these different usages that just seem irrelevant today. Chris, I considered adding necessary and proper to this. We actually, let's keep the same diagram we've used for 3 years, so maybe I can update it later. There was nothing deliberate there, it was just keep the same diagram. We can make diagrams for the other ones, it's very colorful, they're very, very pretty pictures. But I think we have to look, Chris, you had so many points, I forgot them all. Oh, okay, but I think at least one of the points that often gets people angry at us is saying that the president can serve in Congress. Let me just make this point bluntly. If we're right, the president doesn't suddenly become a member of Congress. A lot of things have to happen first. A lot of things have to happen, right? The reasoning behind the incompatibility clause was not worrying about the president serving in Congress. It was about the president bribing members of Congress with lucrative positions. And Steve Calabrese has written this point with Judge Larson, now on the Sixth Circuit, very compellingly, right? Again, I'm a separation of powers scholar. I look at all these things through separation of powers. I have to break that when I'm working with Seth. Say, okay, this is not about American separation of powers. We have to think about how corrupt was the English Constitution and how was our Constitution designed to remedy that. There's some things that framers probably didn't account for because they were focused on the English constitutional system. You have 5 other points. Maybe we'll do a reception later. But thank you all so much. Excellent questions.
Seth, several years ago, I started reading some of your stuff, and I said, he's banging his head against a brick wall, and I was with you on that because sometimes you bang hard enough, the wall cracks a little bit too. But I thought to myself at the time, even if he knocks down the wall, it's not all that important. And I want to just say, reading over the last few years, obviously, I think that wall is worth beating your head up against some more. And I'm persuaded of the importance of what you're doing, rather than simply that it was a kind of an interesting, game with the text, which I thought was an interesting game, but didn't have much public benefit. I agree with John McGinnis. I was hoping you'd do a little more public meaning, trying to show how these words of, under, trust have some integration with broader linguistic usages. Because I think you do show largely, not perfectly, that there's an internal consistency in the text of the Constitution, but I was really hungering for something that showed some consistency with broader legal usage. I know you have some of it there, but I think it's probably a fruitful thing to look into. Third, it seems to me from the discussion of that comma that the comma mattered. That's if it's put in at the very end, and at least when I was studying Latin, where I learned something about English, there's restrictive and non-restrictive relative clauses, and the comma makes a big difference, and it supports your thesis. If you don't have the comma, at least in contemporary English, then it's a restrictive. It says other officers whose appointment, but with the comma, it's non-restrictive. It's the same category, and or in other words, apposition. And lastly, and this is just one of my obsessions, and I'm going to probably bring it up in the next paper too, but of the United States, the only vestings clause is Article 3 that has that for the judicial power. And I would be delighted to know that your work has some kind of relevance to that, because it turns out those are the only people that are officers of the United States, the Supreme Court and the federal judges, by your account, not the president, not the members of Congress. And I was wondering if that of the United States language in Article 3 isn't going to be perhaps illuminated by your discussion of officers of the United States.
So I also really like the paper. I'm not fully persuaded by it, but I'm persuaded that there's enough of a case there. If we could go to the Venn diagram. Yeah, sure. Three thoughts. One, I agree with others. I do think you need the necessary and proper clause up on the diagram. And I think that that's right in part because the text is slightly different. It's not clear that the of is referring to the United States there. The language is, all other powers vested by this Constitution in the government of the United States, comma, or in any department or officer thereof. And it could mean an officer of the government of the United States, which is a different category than any up there. And in part that might make sense even if you're doing a null hypothesis clause by clause reading, because it seems plausible that Congress could pass laws with regard to the very few powers vested in the vice president. That there's something necessary and proper to letting the vice president be president of the Senate, then Congress could legislate on that topic, because that's a power vested by the Constitution, not in a department, not in the government writ large, but in a particular officer. Now, that officer is not an officer of the United States. I'm totally persuaded that the president and vice president are not in the gray circle. But they might be some kind of officer of the government of the United States, which might be somewhere up there. Second thing, I'm less certain about who's in the orange circle. Because, is it really saying that members of Congress can't be the clerk of the House? I mean, maybe, but, I'm not fully persuaded there, though I could well believe you. But I think that it matters a lot because we need to know whether the president and vice president are in the orange circle. And there's some evidence that you give that they are not. We know that they are. We know the presidency is an office. And we know that the presidency is sort of takes under the powers of the United States in some sense. But the question is it an office under the United States? And I think the Hamilton, It is suggestive, but not completely 100% persuasive for me, in part because the list is any civil office or employment under the United States. And I could imagine in context not including the president certainly as a civil, since they're also, he also sits as commander-in-chief of the military. And office or employment under might suggest that we're just looking for a different category, not because there's sort of a legal distinction there, but just that who you think belongs on that list is going to be shaped by the office or employment. And so you're just looking for lower level people than that. The cabinet secretaries on down and Supreme Court justices on down might be a reasonable way to take that in context without necessarily precisely repeating the constitutional categories.
So this is a fascinating and very provocative paper. I want to follow up on John's point about careful drafting and grammatical convention, which David just noted also. And so I think to accept the paper's argument, you need to first assign a kind of intentionality and competence to the drafters that, as Will noted, may be misguided. And in any event, we have to assume that the drafters consistently use language and grammatical convention, right? That's central to the claim about the necessary and proper clause. That's a problem. And to see why, I just want you to consider two later adopted provisions. And I'm hoping that in an originalism conference, people have access to other provisions. I'm not an originalist, and I have my pocket constitution with me. So the 17th Amendment, as written, seems to say that for 6 years, which is to say until 1919, 6 years after it was adopted, the Senate will be selected by direct election. And it doesn't tell us what will happen after that. And if you look at the text of the amendment, you'll see because of its use of commas, that is to say, setting off language by commas into non-restrictive clauses, it doesn't actually do the work that most people think it does. And the 26th Amendment, literally written and understood according to grammatical convention, defines citizens of the United States as people who are 18 years of age or older, again, because of its use of a non-restrictive clause with commas. Now, this creates a dilemma, right? Because either we create constitutional absurdities by reading the text according to its plain language as written and grammatical convention, or we do what I think all of us do with those clauses, which is we smooth out inconsistent usage and carelessness in drafting based on what the paper at one point calls simple intuitions, right, about what the clauses are supposed to do. That's clearly what we do with the 17th and 26th Amendment, and I guess the question is why don't we also do that when we tackle the Constitution's language and usage about offices and officers?
I'll certainly strive to take your comment and John's comment on board. I would say that some of the effort that went to developing an originalist argument was developing the Jacob Henry materials, where
I'm sorry.
Sorry. Some of the effort there was to develop the Jacob Henry materials, which dealt with a motion to expel a sitting member of the North Carolina legislature from 1809. And there was later commentary on it, and the Chief Justice of the state commented on, again, that affair in constitutional ratification process in the 1830s. And the usage of under the state was used there, and he even referenced the Blount trial when he developed his argument to make arguments along that line. So there is something there to show that usage like that was talked about in the antebellum period that is not contemporaneous with ratification. It is a good bit later. One of the reasons I bring that up is to address the point John made, which is that I don't quite think, in this paper at least, I made quite the argument that the Blount trial stands for the universal proposition who is and who is not in office in the United States. I think in this paper what we said was a slightly weaker position, which is that this is the way Blount is usually understood, and we pointed to the Jacob Henry materials. But if I slipped in saying there's only one possible reading of the Blount trial, that would have been an error on my part. I don't think I actually did that, though. Maybe you could point it out to me if I did. As far as, Stephen, your comment about the necessary and proper clause, I actually do think the status of the clerk of the House was, and other administrative officers of the House, was something they were actively considering, to tell you the truth. And I think part of the evidence of that is if you look at the Oaths Clause of the Constitution, even Steve Calabrese admitted in his response to me that the Article 6 actually doesn't cover the clerk of the House and the secretary of the Senate. And there may have been a reason for that. Now, I could tell you that reason, and then you'll walk away thinking I'm a madman, so I'll avoid doing that for now. But the fact is there are problems. One way of looking at at Article 6 is that there's a problem with the drafting. They didn't draft what they meant to draft. The other way to look at it is the way I'm suggesting, which is we've lost constitutional memory of what they were trying to effectuate, so we're saying it's misdrafted. Professor Smith, I never made, at least I don't believe in this paper, I ever made the argument based on commas. That was introduced, I think, by John and some of the other speakers here. I understand the argument, I've considered it, but I don't think in the 100 pages plus I gave you, I ever made any argument developed on the placement of a comma. It's not that I'm opposed to making such arguments. I understand your larger point, and we do make very narrow linguistic points. That's fair, and I understand your point about the 17th and the 26th Amendment. That's fair, too. When I run away from the sort of questions that many here are most interested in. I admit that. I am not a high theorist that I'm going to justify or account for originalism or any other method in the most abstract. I found what evidence I think supports the theory, and I'll let people build that evidence into whatever theory they want. For the life of me, I have never understood why it is that in the last 10 years of writing on this issue, I haven't had one response from any commentator at any level trying to explain how George Washington received a framed portrait through diplomatic channels, a portrait that we could now value because we found actually the receipts in French archives for what the government paid for it, did it in public, put it in the house where all his cabinet members walk through. This was a valuable gift, and not only, there was never any record that I've ever found of any contemporary or any future historian until Trump saying that Washington did anything wrong. Now, if that doesn't validate that the president does not hold an office under the United States per the Foreign Emoluments Clause, all I'm going to say is I don't know what possible evidence I could find to convince you. I mean, what more do I have to find? If you're not convinced by the Hamilton document, here's a gift from Washington. Now, the counter response, you might think, is, well, maybe Washington made a mistake. But in the last 10 years, Cy Prakash and Steve Calabrese and no one in this room and no one in the country has been willing to say in public, in an article or in a brief, that George Washington erred. And I think the reason they don't say that is because they know what people will think of them if they say that. And I mean, you're allowed to say George Washington erred when he signed the Judiciary Act of 1789. The Judiciary Act was a complicated act. You could say Washington and Congress erred with regard to the Sedition Act, which was very contentious. But this was taking a gift. If it was dishonest, if people saw that he was breaking the Constitution.
You mean Adams?
Adams signed the Sedition Act. You're absolutely right. The point is thank you. The usual argument that the founders and the framers and their near contemporaries did things that were unconstitutional doesn't validate the fact that George Washington received this gift, and it was the first major diplomatic gift under the new Constitution. And not only that, there are no later commentators who point to this gift and say, "Wow, this was awfully bad." So I understand your point. We should look to intuitions. I admit I do so myself from time to time. But if I point at the Statue of Liberty or at the Pyramid of Giza and I say, "Look, that's evidence," I'm willing to admit I don't have a theory, but I do have some evidence that no one seems to ever respond to. Now, the one person who did respond to this argument, I think it was in a blog post, was Professor Sugarman, who said simply Washington erred. And that's an interesting point of view. It's not illegitimate, but he hasn't made that in any of his published articles. And neither has anyone else or anyone today or at any other time. So as far as your wider question with regard to consistent usage, one of the things you did, leaving aside the issue of commas, one of the things you did is you looked to later articles. You could probably find examples of inconsistent usage in the original Constitution. I think to some extent Professor McHale did that with regard to the use of appoint and elect. I'm generally sympathetic to what you said on that point. It's not exactly consistent throughout the whole text of the Constitution, appoint and elect. I would say generally it is, though, particularly in the ineligibility clause. But that doesn't mean the phrase office under the United States wasn't used consistently. And if I could develop a detailed analysis showing that it was, I'm not going to say that's presumptively correct, but there's no reason to reach to Bode's null hypothesis if I could present a cogent theory showing it was used consistently. I'll stop.
Yeah. Steve, just one sentence response. Even if the president's commander-in-chief and his military, the vice president's not. The VP is not on the list.
And congressmen are not on the list either.
Right. So we get the argument all the time. It's easy to respond to. Let's go more questions. We're running. Sure. Oh, I'm sorry, John. If you have a response, I'm sorry.
Well, I'll just briefly, in response to Steve, I think you're raising a good point, but the language on the impeachment clause first comes in only with respect to the vice president. So the convention votes up a motion that says the vice president and other civil officers of the United States shall be impeached. That sits for a while. They've also separately affirmed provisions with respect to the president, and Morris combines them. And you can imagine stylistically when you combine 3 instead of 2, one who is, as you say, arguably not a civil officer because of the commander-in-chief aspect, and the other 2, which has been voted up, you might, make the decision that he did. Others doesn't have entailment. It's an implicature-based inference, right? It's just, it's cooperative to use the word other when you know that the prior items in the list have the qualities that they do, but it doesn't, there's no contradiction in assuming deriving from the presence of other in that regard. And I think also there are contexts in which we talk that way. It's the same thing with the Commission's clause, but I'll stop. There's a lot more to say.
But I do want to suggest that the null hypothesis and even more nihilism than that might be appropriate. And my starting text will be on page 87 of your paper. Because you said something that kind of surprised me, and it might suggest that maybe there's more ambiguity and chaos in this document, the Constitution, than you're willing to confront. You said the framers would not have selected ambiguous language in the incompatibility clause, whose meaning could have been contested during sharp conflicts, because such a momentous decision would have risked future majorities oppressing and excluding an otherwise duly elected minority. And I get that. And throughout the paper, you cite Powell v. McCormick for the idea that Congress can't just make up new qualifications. For 150 years, indeed until 1969, when Powell v. McCormick was handed down, every single member of Congress, to my knowledge, thought Powell was wrongly decided, and they had the power to add qualifications. Arthur Gould in 1926 was accused of bribery, and the Senate convened a trial to see whether he had taken a bribe. He was seated, but not because they said, hey, we can't add qualifications. You might ask yourself, so what? Well, either everyone in Congress just got the text of the Constitution wrong for 150 plus years, or the Constitution is really an ambiguous mess on precisely the point that you say they could never have been ambiguous about. Now, the reason why I'm farther than John is on this issue is that although I think each member looked at the document very carefully, in any collective body, you can imagine that the direction of the document will be about as steady as a car being driven by dozens of people. People were throwing in stuff and secretly taking it out and accusing. So my sense is that there's a lot of chaos in this document. But if there's not, please explain to me why you endorse Powell's reading, and how can you explain that literally every member of Congress thought it was wrong? Indeed, Deschler's books of precedent had to be completely revised. This is the House of Representatives' books of precedent in 1969. They had to throw out all the trial precedents in which both the Senate and the House, Hines' book on precedents, added qualifications willy-nilly because they read the language, each house should be the judge of the qualifications of their members, as meaning they could decide whether people were qualified. Bribery, immorality, dueling, bad sex, all of those were bases for excluding members elect.
How do you judge that?
Yeah. I think the term they would have used is whoring. And there was, in fact, a case on that, dueling, violence, you name it. So, I mean, what's going on?
I will say that I started out as a skeptic, as many people did, but at the very least, I would say that this is a very strong and persuasive case. Whether it ultimately succeeds or not, I'm still not sure. There's so many moving parts you have to hold in your head to, at the same time, to really figure out whether it's the best theory. I do agree with the paper that that's the question is, what's the best account of all the language, right? That's what we're looking for. And it might be this, it might be one of the alternative accounts, it might be Will's version or Rick's version, but we're really asking for what's the best account. I agree with the comments you've received about it being important to put the necessary and proper clause in the paper. I do think that's essential. And I do think that you should take into account Steve's reading, which also suggested itself to me that the thereof, the of in the thereof is attached to government and not to the United States. That might be right, it might be wrong. I haven't decided yet, but that syntactic ambiguity immediately suggested itself to myself. If, in fact, it attaches to government, then that adds another category to your set of Venn diagrams. Third thing, at the very end of the paper, page 52 of the paper, page 187 of the materials pagination, you get the closest you get in this paper to addressing the methodological issues that I just think, I know you are trying to finesse methodology, that you're trying to finesse originalist theory, but I really would urge you not to try to completely avoid those questions. You could do some bracketing and discuss alternative possibilities, but just trying to avoid the questions, it seems to me, is unsatisfactory. So obviously your theory is of all the clauses, and especially the under language, is that this was technical language that would have been familiar to lawyers who were educated in sort of parliamentary constitutional discourse. So given the situation of constitutional communication, so this is a constitution that is written for multiple audiences. It is written for we the people of the United States, and it has a popular ratification process. It's written for the kinds of folks who are going to show up at ratifying conventions. They're going to be a select group of the people of the United States with various characteristics, better educated than sort of the median citizen of the United States, but not all lawyers, and certainly not all lawyers educated in parliamentary constitutional theory and fully familiar with that discourse. And of course, it's written to be implemented by future judges and Congress people and members of future presidents and members of the executive branch. So I am not yet fully convinced that the relevant group who would have grasped the full structure of the theory, which is very difficult to grasp, even for someone who has read now hundreds of pages of your writing, and various responses over an extended period of time. I'm not yet fully convinced that if you have identified the communicative intentions of the drafters, and there's some complexity there since it goes through multiple stages of drafting, but it's simplifying vastly, assuming that we're talking basically about a small group who do the final drafting, right? We're talking about a large role for Gouverneur Morris, and then some role, either large, very large, or maybe not quite as large for James Wilson. We have to guess about exactly who's doing how much of the final drafting. Did they successfully communicate this schema to their intended audiences? And I think that here you're entitled to, you're entitled to assume that they would have understood that there's division of linguistic labor, and that the fine points don't have to be fully appreciated by all of the we the people, so long as we the people, citizens generally, and even delegates to the ratifying conventions generally, could have recognized that this is technical language with fine distinctions. And that's enough, in my opinion. If you get that, that's enough. Then we can have a division of linguistic labor, right? But it seems to me that this is essential to your argument working.
Can we just get Christina's question and maybe we'll talk offline?
I'll just stop there.
I'm timing myself for 60 seconds because we're over time. I wanted to ask, from a bigger picture point of view, what the audience for and goals of this book were, especially in light of the fact that on the one hand, this is a meticulous kind of reading of evidence and text in a context that's very politically heated. And there's always a challenge on how to present that kind of material. Do you ignore the fact that there's this other discussion or argument or motivation going on? Do you act defensive? And I think that when you read this, there's an undercurrent of that frustration, and especially in your opening remarks, Seth, about people forgetting things. And I don't know if that defensiveness serves the project of advancing the theory about what the meaning of the words is as well as it could. And I might kind of frame things. I remember reading psychological literature that when someone's really emotionally committed to a certain position, the best way to shake them, you can't put them on the defensive, but to say something like, well, of course you never would have known that office meant this because you didn't have all this evidence that we've now presented. So it makes perfect sense that you were mistaken, but now you can come join us, come have a hug. And I just think that removing the frustration and the anger about people's forgetting constitutional history might help. The last tiny thing is that at the beginning and at the end and in your comments, you say, our purpose is so modest, we're not even trying to convince you that we're right. But if you reframe some of your sentences a little bit, you end up saying, listen, if you believe in the meaning of text, the weight of evidence, and in documents being internally consistent, then you kind of have to think we're right. And so maybe the way to plus one to Larry is to bracket the idea that, listen, if you care about these kinds of evidence, you would think we are right. And I think that's a better way to kind of not pick a theory without picking a theory and not having this false modesty about the paper.
Thank you all very much.